Welcome to Legal Anecdotes. Today, in this video, we are going to discuss a very important and very confusing topic of Indian criminal law, which is called culpable homicide. So, as we know, the Indian government introduced three new criminal laws, which is Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita, and Bharatiya Saksha Adhiniyam, which replaced the current laws, criminal laws, which was in practice till the from the British time, including the Indian Penal Code (IPC), Criminal Procedure Code (CRPC), and Indian Evidence Act. So, in the Bharatiya Nyaya Sanhita, the Bharatiya Nyaya Sanhita (BNS) is going to work like the IPC used to work, right? So, in the BNS, Section 100 defines the culpable homicide. But before going to the real definition of culpable homicide according to the BNS, we'll first know what was the current legal term culpable homicide and what is the meaning of that, and what is the etymological meaning of that, and who coined this term first. So, the term culpable homicide is a legal term that refers to the crime of killing of or causing the death of someone, but not intentionally. However, in the definition of the BNS, like what we're going to study, the word intentionally is included in that. But if we go to the real meaning and from where this term was taken, the literal meaning of the word meant causing the death of someone, but not intentionally. So, if we break down the word culpable and homicide, the word culpable means being responsible for something wrong or blameworthy. And homicide comes from the Latin word homi, which means man, and cido, meaning to cut. So, homicide refers to the killing of one human being by another. So, this is a literal meaning of the term culpable homicide. And talking about who coined this term first, it was Sir William Blackstone, right, who first coined the term culpable homicide. तो जैसा कि बताओ हम जान गए हैं कि इस टर्म का लिटरल और एटिमोलॉजिकल मीनिंग क्या है. हालांकि अगर हम एक लीगल मीनिंग की बात करें जो हमारे बीएनएस में दी हुई है तो वो इससे थोड़ी अलग है, लेकिन ये इसकी लिटरल मीनिंग थी और सर विलियम ब्लैकस्टोन ने से पहली बार इस टर्म को कॉइन किया था. He was an eminent jurist. So now we'll move forward to the definition and the real legal meaning of the term culpable homicide. तो हमारे भारतीय न्याय संहिता में सेक्शन 100 इंक्लूड्स द कल्पेबल होमिसाइड और वो उसको डिफाइन भी करता है और साथ साथ उसके एसेंशियल इंग्रेडिएंट्स को बताता है कि व्हाट ऑल इंग्रेडिएंट्स इज इंक्लूडेड इन कल्पेबल होमिसाइड. So when we read the section 100 of BNS, it says whoever causes death by doing an act with the intention of causing death or with the intention of causing such bodily injury as is likely to cause death or with the knowledge that he is likely by such act to cause death commits the offense of culpable homicide. अगर इसे हम सिंपल लेमैन की लैंग्वेज समझें और उसे ब्रेक डाउन करें तो हम ये समझते हैं कि अगर कोई इंसान कोई ऐसा काम करता है जिसमें उसकी इंटेंशन है सामने वाले की डेथ कॉज करना. अगर ए ने सपोज बी को एक बड़े से रॉड से सर पे मारा तो उसमें उसकी इंटेंशन क्या है कि बी मर जाए. ठीक है, अगर वो इंटेंशन है कि बी मर जाए और फिर भी वो जानते हुए कि ऐसा करने में बी मर सकता है उसने वो एक्ट किया, सो ही इज़ डूइंग कल्पेबल होमिसाइड. इसमें ये इसकी एक इंग्रेडिएंट थी, इसमें और भी चीज़ें इंक्लूडेड है. ठीक है, अगर ऐसा ये तो एक्ट करता है जिससे वो क्लियरली मर जाए या दूसरे पर्सन को उसके डेथ को इंटेंट करते हुए कोई ऐसी बॉडीली इंजरी देता है. फॉर एग्जांपल आपने उसके जैसे बोला कि रॉड सर पे मारा, हो सकता है उसको इंजरी हो, तुरंत ना मरा हो, लेकिन आपने उसे एक ऐसी बॉडीली इंजरी दी इसमें आपको पता है कि उसकी डेथ भी हो सकती है और डेथ नॉर्मल सर्कमस्टांसेस में डेथ उसकी हो जाती है. सो लाइक डूइंग एन एक्ट टू किल दैट पर्सन और गिविंग सच बॉडीली इंजरी विच इज़ लाइकली टू कॉज डेथ और विद द नॉलेज दैट इज़ लाइकली बाय सच एक्ट टू कॉज डेथ. अगर आपको पता है कि ऐसे काम करने से वो मर सकता है. कई बार ऐसा होता है कि कुछ ऐसे एक्ट्स होते हैं जो कि रियल नॉर्मल सिचुएशंस में उसमें किसी की डेथ नहीं होगी, लेकिन अगर कोई स्पेशल केस है कि वो पर्सन कोई डिजीज़ से अंडरटेक कर रहा है और उस सिचुएशन में अगर उसे उस तरह का हर्ट दिया जाए तो वो मर सकता है. और आपको ये चीज़ पता है कि अगर कोई इंसान फॉर एग्जांपल कोई ऐसे डिजीज से सर्व कर रहा है कि उसे एक थोड़ी सी खरोच से भी, जैसे एड्स होती है बीमारी, एड्स में अगर थोड़ा सा ब्लड में निकल जाए तो ब्लड क्लॉट नहीं हो पाता है और वो ब्लड बहता जाता है। तो आपने जानबूझ के उसको एक कट दे दिया हाथ में। नॉर्मल सिचुएशन में उस कट से कोई इंसान नहीं मरेगा, लेकिन क्योंकि ही सफरिंग फ्रॉम अ डिजीज ऑफ सच नेचर, ही कैन डाई। तो आपको पता है फिर भी आप उससे काम करते हो, तो आप यू आर परफॉर्मिंग कल्पेबल होमिसाइड। ठीक है, ये हमारी डेफिनेशन कल्पेबल होमिसाइड की हो गई। अब व्हेन वी गो थ्रू द बीएनएस विल फाइंड देयर थ्री एक्सप्लेनेशंस टू दिस। इसमें तीन चीज़ें और इंक्लूड करी गई हैं कल्पेबल होमिसाइड में। ठीक है, तो वैसे से पहले मैंने बोला एक्सप्लेनेशन वन में क्या दिया हुआ है, अ पर्सन हु कॉजेज बॉडली इंजरी टू अनदर हु इज लेबरिंग अंडर अ डिसऑर्डर, डिजीज और बॉडली इन्फॉर्मिटी एंड देयर बाय एक्सेलरेट्स द डेथ ऑफ द अदर शैल बी डीम्ड टू हैव कॉजेज डेथ। जैसे मैंने बोला, कोई इंसान अगर ऐसी डिजीज सफ़र कर रहा है जिसमें कुछ ऐसी बॉडीली इंजरी जो कि नॉर्मल सिचुएशंस में डेथ काउज उससे नहीं होगी, लेकिन क्योंकि वो उस डिजीज सफ़र कर रहा है और उससे वो इंटेंशन के साथ वो अगर वो हार्म किया जाता है और वो उससे मर जाता है, देन द पर्सन विल बी लाइबल, द ऑफेंडर विल बी लाइबल फॉर दिस कल्पेबल होमिसाइड। राइट, एक्सप्लेनेशन ये है हमारी एक्सप्लेनेशन वन होगी। एक्सप्लेनेशन टू में वहाँ पे दिया हुआ है कि अ पर्सन हु कॉजेज सच बॉडली इंजरी शैल बी डीम्ड टू हैव कॉज द डेथ, ऑल्दो बाय रिस्टोरिंग टू प्रॉपर मेडिसिन एंड स्किलफुल ट्रीटमेंट द डेथ माइट हैव बीन प्रिवेंटेड। फॉर एग्जाम्पल, अगर ए ने बी को मारा, उसे एक ऐसी बॉडीली इंजरी दी और वो इंजर हो गया और वो हॉस्पिटल में गया। सपोज हॉस्पिटल में उसे सपोर्ट स्टाफ्स, डॉक्टर्स ने, वार्ड बॉयज़ ने, नर्सेज ने सही से ट्रीट नहीं किया और वो उस कारण से मर गया। लेकिन फिर भी वो मरा क्यों? क्योंकि ए ने उसे बॉडीली इंजरी दी वैसी। ये बात हम यहाँ पे नहीं देखते हैं कि अगर उसे प्रॉपर मेडिकेशन या प्रॉपर डॉक्टर्स केयर मिली होती वो बच सकता था, लेकिन वो उस अवस्था में पहुंचा ही क्यों? क्योंकि ए ने उसे मारा। सो हियर ए विल बी लाइबल फॉर द डेथ ऑफ द बी, नॉट द सपोर्ट स्टाफ, नॉट द डॉक्टर्स, नॉट द नर्सेज। राइट, क्योंकि ए ने उसे ऐसी बॉडीली इंजरी दी कि वो हॉस्पिटल तक पहुंचा। क्लियर। एक्सप्लेनेशन थ्री जो हमारा बीएनएस का वो कहता है कि द कॉजिंग ऑफ द डेथ ऑफ अ चाइल्ड इन अ मदर्स वूम इज नॉट होमिसाइड। ये बेसिकली बात करता है हमारे पास कि अगर कोई बच्चा अपनी माँ के गर्भ में है, माँ के वूम में है और उससे मारा जाता है तो वो होमिसाइड नहीं होता है, क्योंकि वो बच्चा, क्योंकि होमिसाइड हमेशा भी जब भी होगा, अगर हम कल्पेबल होमिसाइड की बात करते हैं, वो हमेशा एक लिविंग बींग के ऊपर होता है। लेकिन एक जो बच्चा माँ के गर्भ में है वो अब तक लिविंग बींग नहीं है, वो अभी तक जिंदा नहीं है। जिंदा है मतलब बेसिकली वो ह्यूमन सोसाइटी में नहीं आया है, तो हम उसे नहीं मानते। लेकिन ये कल्पेबल होमिसाइड कब हो सकता है? जब वो बच्चा जो उनके गर्भ में है वो दुनिया में आ जाए, मे नॉट इवन वो ब्रीद ना भी करे, ठीक है, वो कंप्लीटली बॉर्न ना भी हो, लेकिन अगर उसका कोई भी पार्ट अगर जिंदा है, वो अर्थ पे या ह्यूमन सोसाइटी में आ गया, फिर वो मरता है, देन दैट विल बी कल्पेबल होमिसाइड और वो कल्पेबल होमिसाइड के कैरेक्टर में आ जाएगी। तो ये हमारे पास सेक्शन 100 कल्पेबल होमिसाइड की डेफिनेशन और उसके इंग्रेडिएंट्स की हमने बात करी कि क्या क्या चीज़ें इसमें इंक्लूडेड होती हैं। कोई बॉडीली इंजरी हो, इंटेंशन ऑफ कॉजिंग डेथ हो, और या फिर कोई ऐसी आपने इनको इंजरी दी जो कि नॉर्मल सिचुएशन में डेथ उससे नहीं होगी, लेकिन ही इज सफरिंग फ्रॉम सच अ डिजीज और डिसऑर्डर और उसमें उसकी डेथ हो गई। सो दिस आर द इंग्रेडिएंट्स ऑफ कल्पेबल होमिसाइड।
As we are now well versed with the uh, basic understanding of the culpable homicide and the all the basic concept of the history or the who coined that term or where this concept came from, we just already discussed about it. So now let's move to the next topic, that is murder and the exception of the murder. So murder is defined under section 101 of the BNS Act 2023 and it was defined under section 300 of the IPC. So what is murder? A murder is just beveled in the two concept, that is a two legal concept, or what we can say a legal magazine, that is the mens rea and the actus rea. The mens rea is a guilty mind or guilty intention to commit an act, or there should be a mens rea in whenever a person just commit a murder. Or if we talk about the another concept, that is a other concept, that is a actus rea, which means that there should be a omission or the act which was committed and there is a consequence of that act, that is an actus rea. So these two concepts really leads to the murder. And in the exception, uh, in the all the exception which we are going to discuss, there is a somewhere there is a lack of that mens rea, because that person really don't want to murder that person, but it just at that moment it just happened. So now There are certain exceptions. The first one is a grave and sudden provocation. When a person committed an act during which he is not in a very conscious, or in when he lose that self control, by just provoking of that deceased person, he just spoke him or he just hurt somewhere in his heart, which really lose that self control of his body, that what he is doing right now is wrong or it is right. So it is a basic the person when just forget that basic self conscious, or just lose that self conscious, is not able to define what he's doing right now is wrong or right, just because that deceased person just provoke him, and all that scenario leads to death. Then it comes under this exception, that is a grave and sudden provocation. So the I really want to mention a case here, that is a Kem Nanavati versus state of Maharashtra, in which it is really properly just pointed out this concept in a very good manner. We actually just made a video on it. You can check it out. We just provide you a link in the description. So it's a basic case study of it, that what happened in that case, and what is a basic decision of, and on which factors that decision was taken by the judges. Now coming to the exception number two, that is in good faith or a private defense. You just done that any act which lead to the death of the person, just because you really want to protect yourself, or in a very good faith, you just kill him. Okay, so right, someone, like if we take an example here, that is, so if someone wants to kill you and he is coming towards you just with his knife and just try to going to kill you, and just you don't have any way to run, and you in your side you just saw a, a stone, and just pick that stone and you just hit towards to the that person who just, which we can say a deceased person right now, just kill him just in the private defense, then you are not committing a murder, you're just protecting yourself, and that is a private defense. Now coming to the exception number three, that is a being a public servant or aiding a public servant acting for the advancement of public justice exceed to the power given to the him by law. Or we can also say that you are just doing that thing as someone or the higher authority just ordered you to do that thing. Like we can say that the army officers who are in border, they don't have their own decision, they just follow the decision of the government. The government just ordered them to kill the opponent army, then it is not considered as in uh, murder of that those enemies. Or we can say that if the state government just ordered the police officer to just lathi charge, or and during that lathi charge someone just just dead, or just that killed by that, or killed by that police servant. Now there is an exception number four, that is a sudden fight or committed without the premeditation. So if there is a, you don't have any intention, that is you don't have any mens rea, you never think of that scenario that it really leads to the fight, and that fight leads to the death. You don't have any foreseenness of these things. So there, I really want to define this concept with a certain essential of it. So there is an, first of all, there should be a sudden fight during this, whenever we just pointing this exception. There should be a heat of passion without a premeditation, that you don't have that I just lose my temper like thing. Okay, so the third one is that without offender having taken under undue advantage, that you don't have that undue advantage, you just in that moment you just committed that thing. and obvious that there should be a death last. So the last exception which we are going to deal with is a death by a person concerned. So if a person is in very great agony, or in a very, he's just tormented by some disease, or he just want a panacea, that is he just want to relieve from all the pain, and he wants you to just kill him. That is a person concerned, that he just want to kill him and you just kill him just to relieve all that pain. So here the death by a person concerned comes into picture. Okay, so now these are the exceptions of that murder, or we can say it, we can only say it a murder exception. Now if we revise all these things, I really want to just one by one recite all the points. That is, the first exception is a grave and sudden provocation. The second exception is in a very good faith or a private defense. A third exception is that is a public order or the murder by the public authority or a public servant. The fourth exception is a committed without a premeditation, and the fifth exception is a death by the person concerned. So these are the all the exception which is defined under the section 101 of the BNS Act. You can also check it out during this watching this video. So that's all.
Let's move forward to the status of culpable homicide in Bharatiya Nyaya Sanhita and Indian Penal Code. Earlier, the section for culpable homicide was section 299 of the IPC, and now it is section 100 of the BNS. The definition of culpable homicide remains the same. The main change is in punishment section. Section 105 substitutes section 304 regarding punishment for culpable homicide not amounting to murder. It now provides a statutory minimum of 5 years imprisonment, whereas there was no minimum punishment under the IPC earlier in such cases. Now, it's time for the landmark cases on culpable homicide. The famous The Empress versus Ganesh Dulli and Gopi Dulli. In this case, a snake charmer showed off a poisonous snake in public without removing its fangs. He placed the snake on the spectator's head to show his skills without meaning to hurt anyone. However, when the spectator tried to push the snake away, the snake bit him and the spectator died. The snake charmer was found guilty of culpable homicide under the IPC because even serious negligence can be considered as having knowledge that harm could occur. Now, the landmark case, Bhagwan Singh vs. State of Uttarakhand. The decision regarding this case was given recently, but the case dates back to 2007. Herein, 5 people were hurt and 2 of them succumbed to their injuries because of celebrity gunfire. The furious bench of the Supreme Court, consisting CJI S.A. Bobre, said there is a rise in the incidents because celebrity firing, as they are seen as a status symbol. A licensed gun that is to be used for protection should not be used in celebratory events as it can turn to be very fatal. According to the evidence collected, the accused held the gun towards the roof of the house. Unfortunately, the bullets got deflected and injured people. The accused pleaded not guilty as he had no intention to cause anyone's death. However, the court noticed that the accused was carrying a loaded gun in public and he did not take proper care of his surroundings. He must have had an idea that the bullets could deflect and hurt someone. The court held him guilty. The offense amounted to culpable homicide under section 299 of the IPC, punishable under section 304 part 2 of the IPC.